Good morning. I'm Gary DeWaal, and this is Bridging the Week for September 11th to 15th, and today is September 18th, 2017. Another non-U.S. financial services regulator cautioned its citizens that some digital tokens issued as part of initial coin offerings may be securities subject to local securities law requirements, while the Securities and Exchange Commission in the U.S. convinced at least one promoter of an ICO to cancel an in-progress offering and refund amounts already paid by investors in Ether, the digital coin of the Ethereum blockchain network. Separately, another criminal proceeding was filed against a trader for spoofing based on his trading activities involving precious metal futures listed on the Commodity Exchange Inc. However, the specific criminal charge for spoofing seems to embrace alleged conduct that occurred before the relevant provision of law was effective in July 2011. I just got back from a quick swing to the West Coast where, among other things, I spoke about regulation to a group of blockchain application promoters, fund sponsors, and potential investors at the CoinHalts conference in San Francisco on September 14th. Frankly, it was exhilarating. So I can now catch up on my day job. Let's get started. Following the release of the report of investigation by the Securities and Exchange Commission in July, that concluded that certain digital tokens issued as part of initial coin offerings may be securities that must be registered with the Commission or exempt from registration requirements, the SEC apparently has begun contacting promoters of ICOs to alert them that their specific ICO may raise registration issues. One organization contacted a few weeks ago was Protostar in connection with its ICO with its digital tokens begun on August 13th to fund its Ethereum-based application. In response, Protostar voluntarily ended its ICO and refunded investments already made by some persons. By the way, Ethereum, as you may know, is another open-source software platform based on blockchain technology like the Bitcoin blockchain. It is more conducive for developers to develop decentralized applications on Ethereum, such as so-called smart contracts. Separately, last week, the UK Financial Conduct Authority joined a host of other international regulators in issuing guidance on ICOs that warn that some ICOs may involve regulated investments and firms conducting regulated activities, and that persons involved in an ICO should therefore consider their potential regulatory obligations. Oh, and you may have heard, last week the leader of a major worldwide investment bank called Bitcoin a fraud. For sure, respectfully, I don't agree. I explain why on the article version of Bridging the Week on the website. Check it out. Last week, a criminal complaint was filed against Andre Flotron, a former precious metal trader for UBS Investment Bank, for engaging in alleged spoofing-type trading activity from at least July 2008 through at least November 2013, involving precious metal futures contract listed on the Commodity Exchange Inc. The complaint was filed in a federal district court in Connecticut. Mr. Flotron worked for UBS from at least January 2006 through January 2014. He currently resides in Zurich, but was arrested last week in connection with the complaint in New Jersey. According to the complaint, on multiple occasions during the relevant time, Mr. Flotron, along with others, placed small lot orders in gold, silver, platinum, or palladium futures contracts on one side of the market close to the prevailing price, and around the same time placed larger orders on the other side of the market, also close to the prevailing price. The objective of the large order, said the complaint, was to, quote, trick other market participants by injecting materially misleading information into the market that indicated increased supply or demand, but was not genuine, end of quote. As soon as at least one lot of a small order was executed, Mr. Flotron would cancel the large order within no more than 5 seconds, alleged the complaint. The complaint charged Mr. Flotron specifically with conspiracy, wire fraud, commodities fraud, and spoofing, although the provision of law addressing spoofing, adopted as part of the Dodd-Frank Wall Street Reform and Consumer Protection Act, was not effective until July 16, 2011. And finally, the Office of Compliance Inspections and Examinations of the Securities and Exchange Commission issued guidance setting forth the most frequent compliance issues it has recently identified in deficiency letters sent to investment advisors under its advertising rule. Under this rule, investment advisors generally are prohibited from using advertisements that contain any untrue statement of a material fact or are otherwise misleading or false. Advertising is broadly defined as any type of written communication intended for more than one person, as well as more traditional advertisements, which are to be used to make a determination to buy or sell a security, or which security to buy or sell. According to OCIE, the most frequent compliance issues involve the use of misleading performance results, misleading one-on-one presentation, misleading claims of compliance with voluntary performance standards, advertisements that contain cherry-picked profitable stock selections, and misleading selection of past specific investment recommendations. OCIE also found that advisors did not have necessarily compliance procedures reasonably designed to prevent advertising practices contrary to regulatory requirements and used advertisements that relied on third-party rankings or awards in a misleading fashion. Well, that's it for this week's edition of Bridging the Week. As always, there is more information in each article and more articles on the article version of Bridging the Week on the website. Check it out. I'm Gary DeWaal. Have a great week, and until the next edition of Bridging the Week, ciao.